Alonso Jr. And now let's discuss all about the 1987 Constitution of the Republic of the Philippines, the Article 3 Bill of Rights, that will be discussed by my group members. But first, what is the Constitution all about? The 1987 Constitution of the Republic of the Philippines was ratified on February 2, 1987 after the end of President Ferdinand Marcos' rule. It outlines the three branches of government: the executive, the legislative, and the judicial branches. The Constitution's preamble emphasizes the aspirations of the Filipino people for a just and humane society, promoting the common good and securing the blessings of independence and democracy under the rule of law. And here are the sections 9 to 22 of the Article 3 of Bill of Rights.
Hi, this is Chris Candelario and I'm going to discuss the Article 3, Section 9, also known as the Bill of Rights. In the Philippine Constitution states, private property shall not be taken for a public use without just compensation. This is a protection of property rights. It means that the government cannot take away someone's property for a public use without paying them for a fairly amount of money. This is to protect the right of property owners. So if the government needs to use someone's property for things like building roads or public facilities, they have to compensate the owner fairly. It's a way to make sure that the property owners are treated fairly when their property is taken for a public purposes. How is the Bill of Rights Section 9 applied and used in our daily lives? The Section 9 of Article 3 in the Philippines Constitution means that if the government wants to use someone's private property for public purposes, they have to pay the owner a fair amount of money. This rule applies to a situation like building roads, public utilities, or even redistributing lands to a farmers. It ensures that the owners are treated fairly and compensated for any loss they may incur when their property is taken by the government. So in our daily lives, these rules protect our rights as a property owners and ensure that we are fairly compensated if the government needs to use our property for a public use. Let's apply the concept of the Section 9 of the Article 3 to a situation. Imagine that the government plans to construct a new public park in a neighborhood. To do so, they need to acquire a piece of a private land that is currently owned by an individual. So here are how Section 9 would apply. The government identify the specific land they need for park and approach the owner of the property. And they engage in the negotiation with the property owner to discuss the acquisition of the land. The government explains their plans for the park and the public benefit will it bring. During the negotiations, both parties consider the fair market value of the land. They take into account factors such as size, location, and the potential use of the property. And the government, the property owner, and towards reaching a mutual agreed upon price of the land. They aim to ensure that the compensation reflects the value of the property unless incurred by the owner. Once an agreement is reached, the government proceeds with the acquisition of the land and pays the agreed upon compensation to the property owner. By following this principle of Section 9, the government ensured that the property owner is treated fairly and receive just compensation for their land. This allowed the government proceed with the constructions of the public park while respecting the rights of the property owner.
According to Article 3, Section 10, no law impairing the obligation of contracts shall be passed is a rule in the United States Constitution that protects the right and agreements made in contracts. It means that the government cannot create laws that weaken or invalidate the promises made in the contract. When people or businesses enter into a contract, they agree to certain terms and obligations. These contracts can cover things like jobs, leases, loans, or business agreements. This rule is important because it gives people confidence that the agreements they made will be respected and enforced. So here is some examples of contracts that could be affected. For example, if a law is passed that bans the import or export of specific goods, it could impact the obligations outlined in international trade contracts. So the purpose of this constitutional provision is to prevent the government from interfering with the terms and obligations agreed upon by the parties involved in the contracts.
Hi, I'm Lavia Bisia and I will be discussing all about Section 11 of Bill of Rights. So, what is Bill of Rights Section 11 all about? Section 11 of the Bill of Rights in the 1987 Constitution of the Republic of the Philippines states that free access of the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. This means that every individual, regardless of their financial status, has the right to access the courts and receive legal assistance when needed. The provision ensures that justice is accessible to all, regardless of their economic background. The provision recognizes that everyone should have equal opportunities to seek justice and have their cases heard, regardless of their economic circumstances. It ensures that individuals who cannot afford legal representation are provided with assistance to protect their rights and interests. By guaranteeing free access to the courts and adequate legal assistance, Section 11 aims to uphold the principle of fairness, equality, and the rule of law. It helps to ensure that justice is not limited to those who can afford it, but is accessible to all members of society. So how is Bill of Rights Section 11 applied and used in our daily lives? In our daily lives, Section 11 guarantees that individuals who cannot afford legal representation are provided with assistance through legal aid programs. These programs offer free or subsidized legal services to those in need, ensuring that they have access to legal advice, representation, and assistance. This allows individuals to protect their rights, navigate the legal system, and seek redress for any legal issues that may face. It's applied and used in our daily lives in a specific situation. For example, consider a scenario where an individual, let's call him John, is involved in a legal dispute but cannot afford a private lawyer. In such a situation, Section 11 ensures that John has the right to access the courts and receive legal assistance, regardless of his financial status. In practice, John can seek help from legal aid programs that provide free or subsidized legal services to individuals who cannot afford private representation. These programs offer legal advice, representation, and assistance, ensuring that John can navigate the legal systems and protect his right without financial barriers. Additionally, if John is involved in a criminal case, Section 11 ensures that he is provided with a public defender, a government-appointed lawyer who will represent him and ensure that his rights are protected during the legal proceedings.
Section 12, Article 3 under the Bill of Rights states that any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. The law shall provide for penal and civil sanctions for violations of this section, as well as compensation to the rehabilitation of victims of torture or similar practices and their families. Let's consider a scenario. Mark is a 25-year-old and called for a questioning by the police regarding a theft in his neighborhood. During the interrogation, the police inform Mark of his right to remain silent and that he has the right to have a lawyer present during questioning. They also inform him that if he cannot afford one, a lawyer will be provided. If Mark decides to answer questions and cooperate, he is told that any waiver of his rights must be done in writing and with his legal counsel present. The police are not allowed to use force, threats, or any form of coercion to make Mark confess to the theft. If they attempt to use such tactics, Mark can assert his rights, and any information obtained through coercion would be inadmissible in court. If Mark is detained for further questioning or investigation, it must be done in a lawful and transparent manner. Secret detention or solitary confinement is strictly prohibited. If the police violate any of Mark's rights during the process, for instance by not allowing him access to legal counsel or using coercive methods, there are legal consequences. Mark can seek remedies and any evidence obtained unlawfully may not be admissible in court. This situation illustrates how these rights come into play in a person's daily life during police questioning, ensuring a fair and just process. In essence, Section 12 is designed to safeguard the rights and dignity of individuals during investigations, ensuring fair and just treatment while also imposing penalties for any infringements on these rights.
Article 3, Section 13. Right to Will. All persons except those charged with offense, punishable by reclusion perpetua. When evidence of guilt is strong, shall before conviction be available by sufficient sureties, or be released recognizance as may provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail should not be required. In short, bail is a matter of right of all accused persons except when the accused commit a crime punishable with reclusion perpetua, 20 years, 1 day to 40 years, and there is a strong evidence, and it is said that a person's right to bail cannot be impaired or weakened or destroyed even if the writ of habeas corpus is suspended. The purpose and form of bail to relieve an accused from imprisonment until his conviction and yet secure his appearance at the trial. The right to bail is granted because in all criminal prosecution, the accused is presumed innocent. It may be in the form of cash deposit, property bond secured, form of surety company, or recognizance, who may not invoke the right to bail. It cannot be invoked where the applicant is not yet in custody of the law, because he went into hiding and it as large, and hence a free man even when he has already been criminal charged in court. It also not available to one charged with capital offense or offense punishable by reclusion perpetua, life imprisonment, or death if the evidence of his guilt is strong. Under the rules of court, no bail shall be allowed after the judgment has become final
or after the accused has commenced to serve sentence.
In Article 3, Section 14, no person shall be held to answer for a criminal offense without due process of law. In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have a compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. In Article 3, Section 14, it is all about the due process of law. It means that the government cannot punish you for crime unless they follow a certain fair and legal procedure. So these procedures are designed to protect your rights and ensure that you have a chance to defend yourself. In Section 14 of the law says that if someone is accused of a crime, they have a certain rights. These certains are important to make sure that they are treated fairly. The law says that they are innocent until proven guilty, and they have the right to defend themselves with a lawyer. They should know what they are being accused of, and they have the right to a quick and fair trial. They can say and question the people who did the crime. They can also ask for evidence to support their side. But if they don't show up for the trial without a good reason, the trial can still go on without them. These rights are there to protect people and make sure they get a fair chance in the legal system. So in our everyday lives, the rights outlined in Section 14 of the law are important for ensuring fairness and justice. So let me give you an example. Imagine that one of your classmates is accused of stealing a phone. So in Section 14 guarantees certain rights to your classmate if they are accused of this crime. So it means that your classmate is considered innocent until proven guilty. They have the right to defend themselves and tell their side of the story with the help of a lawyer. So your classmates should also be informed, but about the specific accusation against them. So they have the right to a trial that is fair, quick, and open to the public. This means that the judge and jury should not be biased and that the trial should not be delayed unnecessarily. Moreover, your classmate has the right to face the person who claims they saw the theft happen. They can ask them questions and challenge their credibility in court. So your classmate also has the right to request evidence such as security camera footage or witnesses who can support their defense. So however, if your classmate doesn't show up for the trial without a valid reason, the trial can proceed without them. So this is to ensure that the legal process doesn't get delayed indefinitely.
Article 3, Bill of Rights, Section 15. The privilege of the writ of habeas corpus shall not be suspended except in cases or invasion or rebellion when the public safety requires it. The writ of habeas corpus means produce the body. The privilege of the writ of habeas corpus is an order coming from the court immediately release the prisoner if the court finds that the detention is without legal cause or authority. The privilege is suspended when courts are momentarily prevented from determining the legality of a detention. It means that you can arrest people who have committed crime or rebellion. In daily life, it may not be directly applicable for most people, but serve as a fundamental protections against arbitrary detention, emphasizing the importance of personal freedom and the rule of law.
1987 Philippines Constitution, Article 3, Bill of Rights, Section 16. All persons shall have the right to speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. So this statement is asserting that every individual has the right to a prompt resolution of their legal matters, regardless of whether they are being heard in a court, a quasi-judicial entity such as a tribunal, arbitration panel, or an administrative body, such as a government agency. Essentially, this means that everyone is entitled to a fair and efficient process when seeking justice or resolving legal issues. The intention is to ensure that people are not subjected to unnecessary delays or prolonged waiting periods in the legal system. Ang halimbawa dito, kunwari, nagsampa ako ng kaso sa isang tao at karapatan ko na bigyan agad ng atensyon upang maging mabilis ang proseso at mabigyan agad ng desisyon ng korte. So, how we can apply and use this in our daily lives? Sa article na ito ay nakakatulong sa aking sarili na mas maging matatag at marunong lumaban na gamitin ng tama ang karapatan na dapat ay para sa atin. At para sa ikakabuti nating lahat, iwasan ang mga bagay na ikakapahamak at mas piliin ang mga tamang gawain at turuan ang sariling sumunod at sumang-ayon sa mga batas ng ating gobyerno basta makakabuti sa ating mga Pilipino. At para na din makaiwas at di na makadagdag pa ng problema sa ating bansa. So tayong mga Pilipino, magtulungan tayo upang mas maging angat pa ang ating bansa sa pamamagitan din ng pagtulong at pag-iwas ng mga masasamang gawain. So, yun lang po at maraming salamat.
Article 3, Section 17. No person shall be compelled to be a witness against himself. So, what is this section all about? This section is all about the right against self-incrimination is accorded to every person who gives evidence, whether voluntary or under compulsion of subpoena, in any civil, criminal, or administrative proceeding. However, the right can only be claimed when a specific question is incriminatory in character is actually put to the witness. It cannot be claimed at any other time. It must not give a witness the right to disregard a subpoena, decline to appear before the court at the time appointed, or to refuse it to testify altogether. So how does it apply and used in our daily lives? It is applied when someone is accused of robbery. For example, he has the right not to provide, which would build his guilt. An employer, however, has the right to ensure that an employee is fit for the duties he is to perform.
Good day everyone, I am Mercy Margaders. So today I will be discussing to you the Section 18 Article 3 of the Bills of Rights. So what are the provisions says? In the first paragraph of Section 18, it says that no person shall be detained solely by the reason of his political beliefs and aspirations. So the provisions ensure that individuals cannot be arrested or held in custody just because of her opinions or goals, and it protects the freedom of thought expressions and political affiliations, which are fundamental rights in a democratic society, and it aims to prevent government expressions of dissent or ideological views, of upholding freedom on conscience and protecting individuals from arbitrary detention or persecutions.
In the second paragraph, it says that no involuntary servitude in any form shall exist except as a punishment for a crime whereof the party shall have been duly convicted. So these provisions prohibits any form of involuntary servitude except as a lawful punishment for a crime after due process of law. Involuntary servitude refers to the conditions of being forced or provide service against one's will. The intention behind this provision is to protect individuals from exploitation, forced labor, and slavery-like practice. It ensures that individuals have the right to freely choose their employment and work conditions without being subjected to coercion or forced labor. It permits of involuntary servitude of a method of punishment for crimes, guaranteeing that persons are only obligated to perform labor or supply service as a lawful consequence.
According to 1987 Constitution of the Republic of the Philippines, Article 3, Section 19, Paragraph 1. Excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless, for compelling reason involving heinous crimes, the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. This section guarantees the protection of individuals from cruel and inhuman punishment, excessive fines, and the death penalty. It highlights the government's duty to promote and respect human rights and dignity, even for those who have been convicted of crimes. The section also allows for the possibility of the death penalty for heinous crimes, but only if there are compelling reasons for it and if Congress provides for it through legislation. Paragraph 2. The employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or indicate penal facilities under subhuman conditions shall be dealt with by law. Meaning, each person detained is entitled to a proper treatment and protection. Any detainee or prisoner in the jail encampment who is subjected to emotional or physical torture should not be tolerated and be dealt with according to the law. When a punishment is cruel and shocking to humankind's conscience, and it comprises the person being punished to suffering and misery for an extended period of time, this law is created to protect them. Under this law, no one is allowed to take advantage or to cause any harm to a prisoner, even how heavy his or her sins or crime they committed. They also have the right to have enough meal, medical service, and proper rehabilitation. Let us always remember the objective of the Bureau of Corrections, which is to make the prisoner regret and correct all their sins for the betterment of their lives.
Article 3, Section 20 state that no person shall be imprisoned for debt or non-payment of a poll tax. This provision prohibits the imprisonment of individuals solely due to their inability to pay debts or poll taxes. It recognizes that debtors should not be subjected to imprisonment as a means of collecting debts or enforcing payments. Numerous people have been in a position where we have to be in a debt or due to the fact that it is the easiest way to get the necessary money. However, paying the money back is presumably the most troublesome thing to do. Indeed, a debtor who refused to pay owes a severe penalty and should be sentenced to jail for his heinous behavior.
Philippine Constitution, Section 21. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Right against double jeopardy means that when a person is charged with an offense and the case is terminated either by acquittal or conviction or any other manner without the express consent of the accused, the latter cannot again be charged with the same or identical offense. Existence of double jeopardy. Requisites under present law and jurisprudence the accused is placed in double jeopardy if the following conditions are present. He has been previously brought to trial in a court of competent jurisdiction. Under a valid complaint or information, he has been arraigned and pleaded to the charge. He has been convicted or acquitted, or the case against him has been dismissed or otherwise terminated without his express consent, and he is being charged again with the same offense. Rule: in case of mistrial, the right cannot be invoked where a petition for declaration of mistrial is granted on the ground that the proceedings have been vitiated by lack of due process. Right to appeal in criminal cases. The government has no right, therefore, to appeal from a judgment of acquittal. The accused, after having been convicted, may appeal to a higher court, but the latter may raise the penalty imposed on him by the lower court, and such is not second jeopardy. Classes of double jeopardy. For the same offense, under the first sentence, the protection is against double jeopardy for the same offense and not for the same act, provided he is charged with a different offense except if the act is punishable by a law, and an ordinance in which the convictions or acquittal under either shall constitute a bar to another prosecution for the same act. For example, if the person commits murder and he was filled with a case of the family he murdered, and if the case was already dismissed because they don't have enough evidence or witnesses of the one who murdered, then the case is finished and they are not allowed to file again in the court.
In Article 3 or Bill of Rights, Section 22 of 1987's Constitution of the Philippines, it states that no ex post facto law or bill of attainder shall be enacted. Applying this constitutional provision, the Supreme Court of the Philippines has held that the prohibition applies only to penal law, one which assumes to regulate civil rights and remedies only, but in effect imposes a penalty or deprivation of a right which, when done, lawful. In Latin word, from after the action or after the facts. One which deprives a person accused of a crime of some lawful protection to which he has become entitled, such as the protection of a former conviction or acquittal or a proclamation of amnesty. One which makes an action done before passing of the law, and which was innocent when done, criminal, and punishes such as action. One which aggravates the crime or makes a greater than when it was committed. One which changes the punishment and inflicts a greater punishment than which the law annexed to the crime when it was committed.